Race and School Admissions, the 14th Amendment and the Civil Rights Act of 1964. The 14th Amendment says, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. Nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. Mendez versus Westminster was a California case from the 1940s involving this constitutional question. Was the segregation of Mexican American students into separate Mexican schools unconstitutional? Five Mexican American families challenged the practice of Mexican school segregation in the United States District Court for the Central District of California in Los Angeles. They claimed that their children, along with 5,000 other children of Mexican ancestry, were victims of unconstitutional discrimination by being forced to attend separate schools for Mexicans. Judge Paul J. McCormick ruled in their favor. He said the segregation of Mexican American students violated the right to the equal protection of the laws, even if they were provided the same technical facilities, textbooks, and courses of instruction that are available to the other public school children. He said, quote, Spanish-speaking children are retarded in learning English by lack of exposure to its use because of segregation, and that commingling of the entire student body instills and develops a common cultural attitude among the school children, which is imperative for the perpetuation of American institutions and ideals. A few years later, the Brown versus Board of Education case asked this constitutional question. Does the segregation of public education based solely on race violate the Equal Protection Clause of the 14th Amendment? Here, African American students were denied admittance to certain public schools based on laws allowing public education to be segregated by race. They argued that such segregation violated the Equal Protection Clause of the 14th Amendment. The plaintiffs were denied relief in the lower courts based on Plessy versus Ferguson, which held that racially segregated public facilities were legal so long as the facilities for blacks and whites were equal. This was called the separate but equal doctrine. Chief Justice Earl Warren delivered the opinion of the unanimous court. He said the Supreme Court held that separate but equal facilities are inherently unequal and violate the protections of the Equal Protection Clause of the 14th Amendment. The segregation of public education based on race instilled a sense of inferiority, according to the court, that had a largely detrimental effect on the education and personal growth of African American children. In 1964, 10 years after Brown versus Board of Education was decided, the Civil Rights Act of 1964 was passed. Title II of that act says all persons shall be entitled to the full and equal enjoyment of the goods, services, facilities, privileges, advantages, and accommodations of any place of public accommodation, as defined in this section, without discrimination or segregation on the ground of race, color, religion, or national origin. This applied to any inn, hotel, motel, or other establishment which provides lodging to transient guests. It applied to any restaurant, cafeteria, lunchroom, lunch counter, soda fountain, or gasoline station, to any movie picture house, theater, concert hall, sports arena, stadium, or other place of exhibition or entertainment. Title IV of the Act said nothing herein shall empower any official or court of the United States to issue any order seeking to achieve a racial balance in any school by requiring the transportation of pupils or students from one school to another or one school district to another in order to achieve such racial balance, or otherwise enlarging the existing power of the court to ensure compliance with constitutional standards. Title VI of the Act said no person in the United States shall, on the ground of race, color, or national origin, be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any program or activity receiving federal financial assistance. Title VII said it shall be unlawful employment practice for an employer to fail or refuse to hire or to discharge any individual or otherwise to discriminate against any individual with respect to his compensation, terms, conditions, or privileges of employment because of such individual's race, color, religion, sex, or national origin, or to limit, segregate, or classify his employees or applicants for employment in any way which would deprive or tend to deprive any individual of employment opportunities or otherwise adversely affect his status as an employee because of such individual's race, color, religion, sex, or national origin. In the case of Swann versus Charlotte-Mecklenburg Board of Education, the Civil Rights Act had to be interpreted. The question was, can federal courts mandate busing programs to integrate schools as a remedy for past state-imposed segregation? After the Supreme Court's decision in 1954 in Brown versus Board of Education, little progress had been made in desegregating public schools. In the Charlotte-Mecklenburg, North Carolina system, approximately 14,000 black students attended schools that were either totally black or more than 99% black. Federal courts ordered the use of mandatory busing programs in order to achieve a racial balance in the schools. In a unanimous decision, the court upheld the district court's use of busing to achieve racial balance in the schools. The court ruled that 1. Remedial plans were to be judged by their effectiveness, and the use of mathematical ratios or quotas were legitimate starting points for solutions. 2. Predominantly or exclusively black schools required close scrutiny by courts. 3. Non-contiguous attendance zones as interim corrective measures were within the court's remedial powers. And 4. No rigid guidelines could be established concerning busing of students to particular schools. In Regents of the University of California versus Bakke, 1978, the question was, did the University of California violate the 14th Amendment's Equal Protection Clause and the Civil Rights Act of 1964 by practicing an affirmative action policy that reserved a specific number of places for minorities, resulting in the rejection of Alan Bakke's application for admission to its medical school? Alan Bakke, a 35-year-old white man, twice applied for admission to the University of California Medical School at Davis. He was rejected both times. The school reserved 16 places in each entering class of 100 for minorities, as part of the university's affirmative action program. Bakke's GPA and test scores were higher than any of the minority students admitted. Bakke contended that he was excluded from admission solely based on race. There was no single majority opinion. 4 justices said that any racial quota system supported by the government violated the Civil Rights Act of 1964. 4 justices said the use of race as a criterion in admissions was constitutionally permissible. Justice Lewis Powell, Jr. cast the deciding vote, ordering the medical school to admit Bakke. Powell argued that the rigid use of racial quotas violated the Equal Protection Clause of the 14th Amendment. but that the use of race as one of several admission criteria was permissible. In Grutter versus Bollinger from 2003, the question was, does the University of Michigan Law School's use of racial preferences in student admissions violate the Equal Protection Clause of the 14th Amendment or Title VI of the Civil Rights Act of 1964? In 1997, Barbara Grutter, a white resident of Michigan with a 3.8 undergraduate GPA and an LSAT score of 161, applied for admission to the University of Michigan Law School. She was denied admission. The law school admitted that it uses race as a factor in making admissions decisions because it serves a compelling interest in achieving diversity among its student body. In a 5-4 opinion delivered by Justice Sandra Day O'Connor, the court held that the Equal Protection Clause does not prohibit the law school's use of race in admissions decisions to further a compelling interest in obtaining the educational benefits that flow from a diverse student body. Because the law school conducted a highly individualized review of each applicant, no acceptance or rejection was based automatically on a variable such as race, and that this process ensured that all factors that may contribute to diversity were meaningfully considered alongside race. Fisher versus University of Texas was a 2016 case. Abigail Fisher, a white female, applied for admission to the University of Texas but was denied. She did not qualify for Texas's top 10% plan, which guarantees admission to the top 10% of every in-state graduating high school class. For the remaining spots, the university considers many factors, including race. Fisher argued that the use of race as a consideration in the admissions process violated the Equal Protection Clause of the 14th Amendment. So does the University of Texas's use of race as a consideration in the admissions process violate the Equal Protection Clause of the 14th Amendment? The Supreme Court said that the use of race as a consideration in the admissions process did not violate the Equal Protection Clause of the 14th Amendment. Educational diversity is a compelling interest if it is expressed as a concrete and precise goal that is neither a quota of minority students nor an amorphous idea of diversity. The University of Texas's plan was narrowly tailored to serve this compelling interest, and there were no other available and workable alternatives for doing so. Justice Clarence Thomas wrote in dissent that the Equal Protection Clause of the 14th Amendment categorically prohibits the use of race as a consideration in a higher education admissions process. Students for Fair Admissions Incorporated versus President and Fellows of Harvard College, 2019. In November 2014, a nonprofit membership group called Students for Fair Admissions filed a lawsuit against Harvard University. The suit alleged that Harvard discriminated against Asian American applicants and altered admission scores in order to continue to maintain a racially balanced student body. The share of Asians at Harvard peaked at over 20% in 1993, then immediately declined, and thereafter remained roughly constant at a level 3 to 5 percentage points lower, even though the Asian American population has more than doubled since 1993, as has the number of highly qualified Asian American applicants. Asian Americans have the lowest acceptance rates at Ivy League universities for each SAT test score bracket, having to score, on average, approximately 140 points higher than a white student, 270 points higher than a Hispanic student, and 450 points higher than a black student. Although Asian Americans had higher admission scores in the academic and extracurricular categories, Asian Americans consistently fell behind in one specific category, personal scores related to personality and character. The analysis conducted by a Duke University economist found that only 20% of high-performing Asian Americans received high personal ratings, compared to 28% of white Americans, 41% of African Americans, and 32% of Hispanics. In October 2019, Judge Allison D. Burroughs ruled that Harvard College's admissions policies do not unduly discriminate against Asian Americans. She said there is no evidence of any racial animus whatsoever, and no evidence that any admission decision was negatively affected by Asian American identity. In February 2020, SFFA filed an appeal in the United States Court of Appeals for the First Circuit. The court heard oral arguments in mid-2020 and ruled in late 2020 in favor of Harvard, concluding that Judge Burroughs had not erred in her ruling and major factual findings. The Justice Department, under President Donald Trump, filed a friend of the court brief in both the initial hearing and the appeal, arguing that Harvard University unlawfully discriminates against Asian Americans by racially profiling students throughout the admissions process, unlimited by any serious constraints, and imposes a racial penalty by systematically disfavoring Asian American applicants. Under President Trump, the Department of Justice also sued Yale University in 2020, arguing that its admissions policies discriminated against Asians. In February 2021, under President Joe Biden, the Department of Justice dropped the lawsuit against Yale. In late February 2021, nearly 7 years after the proceedings were commenced, SFFA petitioned the Supreme Court of the United States to hear the appeal. Harvard filed an opposing brief, which is supported by the Biden administration. In January 2022, the Supreme Court agreed to hear the case.